Very warm welcome to you. This is Magicbricks Now, India's first property channel, and you're watching Property Hotline. I'm Kavita Krishnan. Today we are answering all your legal queries with Nirav Jani. Nirav is associate partner at Hariani Co. He joins me in our Mumbai studio. Nirav, welcome to the show. Let's get started with a question that's coming on our website, www.mbnow.in. Puneet Kinariwala has written in, he wants to know if having the TDR in the society's name is a prerequisite to get IOD. He also asks if conditional IOD can be granted. That's a very interesting question there. And, why don't you start by breaking down what is TDR and IOD for our viewers before you answer that question?
Yes. So TDR, the full form is Transfer of Development Rights. These are the rights that emanate from the land and can be used and which are used for the purpose of development of the property. Now, if a society is the owner of the land and the development is being carried out and the developer is entitled to load TDR, that means use additional FSI from some other property onto this property, and he wants to use that, then he will have to buy it in the name of the society because the society is the owner. However, it's not a prerequisite for an IOD because it can also be done during construction, wherein he can buy the TDR and amend the plans. So it depends on at what stage does the developer want to utilize the TDR, but in both the stages it will have to be in the name of the society if the society is the owner of the land. Now, as far as the conditional IOD is concerned, IOD itself comes with a lot of conditions, and the full form of IOD is Instrument of Disapproval. So if you have a look at the IOD, it reads as your permission or your permissions have been disapproved for the following reasons, and if you comply with these conditions, then you shall be granted the approval. IOD typically is when the plans for the entire building is sanctioned, the FSI is noted by the corporation, and the floors and the number of floors of the building have been marked for the property. When all these three essential things are done and some basic conditions are fulfilled, then the IOD is granted. But IOD itself comes with conditions, and upon complying with those conditions, the CC is being granted.
Right. So essentially what Nirav is telling you here is that TDR is the IOD is the initial permission that you need to take even before you get the construction certificate, the commencement certificate as it is called, to actually start constructing the building. So this is the first approval that you essentially need to take when you get your plans sanctioned from the local body. Now when you do that, the TDR that is there on the side. Now TDR is essentially FSI that you can buy, that you can trade, that can be moved from place to place. So FSI from Lower Parel can be used in Bandra, for instance. Now this TDR which you buy from the market has to be bought in the name of the society. So that's something that you need to remember, Puneet. It has to be bought in the name of the society, and also ideally, yes, it should be mentioned when you're taking IOD, but like Nirav just told you, IOD is the initial approval that you are taking, and like he said, it's intimation of disapproval, which means there are conditions that you have to comply with. So if there is TDR that you are going to load or use on that particular plot, then the local body needs to be informed about it. You need to get the green signal for doing so. Let's take an email query next. R. Ramanathan has written in, and he says he booked a 2 BHK flat in Runwal Greens at Mulud, Mumbai for 6,000 rupees per square foot in 2010. He registered this flat in 2015. When he received the stamp duty and registration details from the builder, however, he found that the area of the flat was increased by 82 square feet. He's got a bigger flat. Now, Nirav, this is due to the conversion of the flower bed area. The builder is obviously charging for this extra space at 1,000 rupees per square foot for the entire built up area. So the flat cost has now gone up by 11 lakh rupees. So he wrote to the builder, asked the builder to charge him the booking rate multiplied by the extra area. But the builder has refused to accept this. He's instead insisting that Mr. Ramanathan pay him 11 lakh rupees. He also adds that the builder is refusing to hand over the keys until this amount is paid. What can he do?
Okay, so as I understand that the change from flower bed to usable area, that is by paying the premium for fungible, has happened post, because earlier that area would have been shown as flower bed, and subsequently the developer has decided to pay the premium for fungible and make it a proper usable area within the FSI and not as a flower bed. Now, if you have consented to this and consented to the price that the developer is going to charge, because it's no more free of FSI, because flower bed would have been free of FSI, and now since he's paid the premium of fungible FSI, it's not free of FSI, and therefore he's asking for a price. So it's a commercial agreement that needs to be entered between the purchaser and the developer. So if you have agreed to these conditions of change and the price, then you will have to pay. If at all you were not aware of all these conversions and you had come to know for the first time when this 82 square feet was known to you after completion, then of course it's a new term and the builder is requesting or is demanding a further amount now, then you can flatly refuse it and say that this was never told to you that this conversion is going to happen and that you're going to be liable to bear extra amount, and you may say that please hand over me the flat as per the agreement as agreed.
So essentially, Nirav, what you're telling is if the developer had written to him, because we know that some of these rules did change in Mumbai midway, and fungible FSI was something that was introduced midway through probably the life of this project, as it happened with many other projects in the city. So in that case, if the developer had written to buyers, then the developer is well within their rights to charge that extra amount. Is that what you're saying?
Yes. So because the developer is now saying that I'm going to grant you additional area, which is now a proper usable area within the FSI and not to be used only for flower bed purpose as it was earlier. You will have to pay extra amount for it. So you have to agree to that extra amount, and only then you can proceed further.
So do you have to sign a separate agreement?
Yes, you will have to enter into some sort of an understanding, either by way of letter, email, or agreement, wherein you're known and you're being made aware of this fact that there has been a change in the area of the flat. A flower bed that was only meant to be used for flower bed can now be used for all other purpose because it forms part of FSI. And for that purpose, you'll have to pay an extra amount of rupees so-and-so, calculated so-and-so rate.
So essentially, Mr. Ramanathan, if you've heard from the developer during the course, before he actually made this demand to you, if you've heard from the developer earlier, if they've written to you saying that this is how rules have changed, this is how prices will go up, then the developer is well within his rights. However, you will need to sign some sort of an agreement agreeing to the new terms and then pay that money. If not, you can seek legal recourse. What exactly can he do?
Yes, he can say that I have never agreed to this, so this has come for the first time. You have unilaterally gone forward and changed the user without asking me whether I'm ready and willing to pay for it. So I am declining. So you please grant me the flat as agreed in the agreement which I signed.
So essentially then, if the developer says no, he goes to court?
Yes.
Okay. So that's your answer. If the developer says no and if you do not, then you can actually seek legal recourse and ensure that you get the flat that you paid for. Next up, a caller on the line from Bengaluru. Bhaskaran, ask your question.
Yeah, good evening. I am speaking from Bangalore. I booked a flat in...
Yes, Bhaskaran, we can hear you. Tell us what's your question.
I booked a flat in the lake veranda of Hiranandani in Bangalore 2010. After a considerable delay of almost 5.5 years, finally it was registered on end January. The only hitch there is because there was a public interest litigation and various issues, so there was a considerable delay. So the flat was registered without the OC, occupation certificate. My question is it illegal to register any flat without OC, or is it illegal to move into the flat without OC? What are the risks involved if you are moving into the flat without OC? Bangalore, many of the flats, people move in without OC. So my question is, one is the legal issue, another one is the practical issue. What are the implications of
Right, Bhaskaran, that's a great question that you're asking, and in fact it's one that a lot of home buyers are currently confronting across the country. Developers are saying that we are giving you partial possession, we don't have the OC, the flats are ready, you can move into it. Should buyers take up on what the developer is saying? Should they actually take possession of such homes?
Yes, so he has two questions. The first question is that whether you can register a document without an OC. The answer is yes, because the flats get sold and the prerequisites for registration of a document would be sanction plans, IOD and commencement certificate. As far as you have the commencement certificate which says you can build a particular amount of floors and the flat that you're selling is within that floor, you can very well go and sell that flat and register the document. So there is no prerequisite of having an OC to register. As far as moving in is concerned, yes, the law very strictly says that you can only occupy a premise once an occupation certificate has been granted by the relevant corporation. Therefore, even the buyer or the purchaser who moves into or takes possession without an OC takes it at his own peril and will be also exposing himself to prosecution and other law enforcements that may be available in the Corporation Act. And you will not be entitled to have any equities saying that the flat was ready and you've been residing here for XYZ years and so on and so forth if the OC is not there.
Right. So, two key takeaways there for all viewers who are tuning into this show, for all those home buyers who are waiting for possession of their homes across the country. Two things that you need to remember. You can register your flat without an OC. You don't need an OC for flat registration, for agreement registration, I'm sorry. And second, and very important takeaway that's coming from what Nirav just told us, is that when you cannot occupy a flat without the OC, you cannot take possession without the OC. It is illegal for the developer to give you possession, and it is illegal for you to take possession without the OC, which is the occupancy certificate. So ensure that you have your OC in hand and then you move into that home. Question coming in on our website next. Karan writes in and says his aunt bought a property, registered it in her name. Now his aunt passed away recently. The project is still under construction. Possession is expected by the end of the year. Now Karan's aunt did not leave a will. The family has decided who will inherit the property. How do they transfer it? There's no will. What do they do?
So typically, the moment aunt expires without a will, the inheritance happens as per the Succession Act that she's governed as per her religion. Presuming if she's Hindu, then Hindu Succession Act. If she's Parsi, then Indian Succession Act. If she's Christian, then Indian Succession Act, so on and so forth. So the moment the individual expires, the property stands vested in the legal heirs, that is as per the Succession Act, and they become legally entitled to the property. So thereafter, if you want to divest and have only one person inherit or one person be the owner of the property, you will have to enter into some sort of an document by which the rights are transferred to the person to whom they have decided that the property should go. So they can enter either into a release deed, they can either enter into a gift deed. If there's a consideration exchange, then they can enter into a sale.
Okay, so that's the procedure that you need to follow. Next up, an email query coming in from SS Verma. Now, Mr. Verma says that his society has not issued share certificates in spite of it being formed 3 years ago. Now, all the payment and the paperwork is complete. Share certificates have not been released to anyone, despite them following up regularly. Now, he wants to know if he can stop paying monthly maintenance in protest against non-receipt of share certificate. What are the penalties that can be applied by the deputy registrar in this case? Now, that's a fine way of protesting, Nirav, but if he stops paying maintenance, won't he be, won't he be pulled up for default?
Yes, certainly. So, because there may be a default on the society from issuing share certificate, that does not mean that you counter it by non-paying maintenance, because that will also be a default, and a default does not kill a default. They both will have to be dealt with independently. So, I don't suggest you to stop paying maintenance. However, you have recourse available, presuming where the society is located. As per the Cooperative Societies Act, you have a registrar that is designated. Please complain to the registrar that though the society is formed, the shares have not been issued, and to direct the managing committee of the society to issue share certificate.
Nirav, how soon should a society ideally be issuing a share certificate once the society is formed?
Typically, there is no set time, but maybe anytime between 3 to 6 months, I think so. Is when they should start issuing share certificates.
3 to 6 months, and he's waited for 3 years and more. So it's a fairly long time to wait for those share certificates. Also, before we move on very quickly, what is a share certificate? Why is it so essential that you have the share certificate for your flat?
So how it typically works is that the society is consisting of all the flat purchasers who come together and form a society under the Cooperative Societies Act. The society is a legal entity and having its own perpetual succession. So it then becomes the owner of the building and the land, and therefore the builder and the developer transfers the building, the land and the management to the society. Now, because the society is vested with the building, the maintenance, management and the land, the members, that is the flat purchasers, are issued shares of that society by virtue of which they are entitled to enjoy the property and all the benefits and the other rights that go along with that. Therefore, share certificate is very important because that will give you the right to enjoy your property and be a member of the society and enjoy all the benefits there too.
So also it is a share in the title of the land that is owned by the society?
Yes.
And whatever benefits you get from that land.
Certainly.
Title.
So the society is the owner of the land by way of a conveyance.
What if the society has not got conveyance? Then is a share certificate issued?
Yes, because either the conveyance would have been pending, or the conveyance would be in the process of being given, or there may be still more development that is to be done. So the society will still be in place as far as the maintenance, management and otherwise is concerned. So for enjoying the benefits and the other activities, you will have to become a member. For example, liftman, watchman, services, utilities, so on and so forth.
Right. So time for a short break on Property Hotline, but let me just quickly recap what Nirav just said, and which is very, very important if you are buying a flat in a new building. A share certificate is something that you are entitled to. It gives you your right over the land, the land title that is owned by the society. It's your share of the land title, and you should ideally be getting this within 3 to 6 months after the society is formed. Even if there is no conveyance, that is, even if the land has not been transferred to the name of the society by the developer concerned, even then you should be getting a share certificate. So if you've not been issued one, it's time you go and ask for that. Let's take an email query next. The individual who's written in has requested to be anonymous. Now he says that some land in Maharashtra and a 2-floor under construction building was distributed equally in his father's and brother's name. This property is currently in his grandmother's name. Now his grandmother stays with his uncle and the property papers are also with the uncle. Now he wants to know how he can ensure that the property will be divided equally if his grandmother passes away. Sounds like a family dispute over there. How would you answer this, Nirav?
Yes, so one of the most simplest ways of doing is to make a registered will, wherein she expresses a desire as to how the property is to be bequeathed or how it is to devolve post her demise. However, since we all know that wills are and do have potential risk of litigation because it being challenged, so in the event you want to avoid that, then the grandmother can also adopt a route wherein she can gift it during her lifetime in the manner which she desires.
So that would be the easiest, the cleanest thing to do.
Yes, because
that she just gifts it to both the...
Yes, because it will be done during her lifetime, and then there's no... It eliminates the risk of anybody challenging it, and during her lifetime, whoever she wants becomes the owner, and then there is no potential risk of the will being challenged post
So
her
she has
demise.
to make a gift deed, essentially.
Yes, and register it.
And register it. So, right, so anonymous, so whoever's written in, this is your answer. The best way to do this, and the easiest way, the cleanest way in fact, would be to get your grandmother to gift the property in the way she chooses to both the brothers concerned. If not, then you have the option of getting a will written during her lifetime and registering that will as well. Next question comes in through our website, mbnow.in. Siddesh says he bought a property in TVH Swasti in Chennai, received possession 4 years ago. Now till date, most of the amenities have not been delivered. They do not have a water connection and the corpus fund has not been returned. What legal recourse can they take against the builder? That is quite serious. No water connection. There is no... the builder has collected a corpus fund, not passed it on to the society.
Yes, so it appears to be quite strange as to how possession has been granted and people are residing without any water connection, because that's the prerequisite to an OC or people moving in, and a basic necessity. However, be that as it may, they must immediately write a letter to the builder asking him to give the water connection and to comply with all the requisites and refund and give them back the corpus fund. In the event he fails to do so, then they can adopt the civil remedies that are available to them, including approaching a consumer court, because that may be faster remedy.
But Nirav, it's been 4 years since they have moved into these flats. At least that's what he says. If that is the case, are they within the time limit? Can they still go to the consumer forum?
Yeah, so they'll have to see as to on how the events have spanned out in this 4 years and where and when the cause of action arises. In the event it appears that the cause of action has arisen much before and they have not done anything about it, then there is a possibility that the defense would be from the developer that it is beyond limitation. But it can still be seen as to how and what the communication has happened between the parties during these 4 years to see as to whether you're still within limitation.
Also, very quickly, Nirav, bringing your attention to what you said yourself some time back about OC. Now, they've not got water connection. Sounds like they probably don't have OC for the particular property, which is probably why they've not got the water connections in place. Now, if that is the case, if the society as a whole doesn't have OC, then can they actually go to court and seek legal recourse over here?
Yes, of course, because their principal prayer to the court would be that directing the developer to grant them the water connection and to obtain the occupation certificate from the relevant municipal corporation, and they are entitled to, for that purpose, to go to court. Now, whether they are in themselves in breach of a section of a Municipal Corporation Act which says that you are not entitled to enter into a premise or occupy a premise without an occupation certificate, that is upon the municipal corporation to take their action.
Right. So you can seek legal recourse there, but if you've not got OC, then it will be a bit of an uphill battle for you to actually convince the court that you are completely in the right. Anish Nair has written in to us via email, and he wants to know whether a resident can apply for e-Khata at the Panchayat for an under construction property that is yet to obtain OC. I'm guessing this is from the Bangalore market. He also wants to know what will happen if such an e-Khata issued by the Panchayat undergoes a change in location when it comes under the BBMP's limits at a later stage. He asks if the BBMP will absorb the same onto their system in such a case. Now, this is also a problem with Pune. A lot of villages are getting absorbed into the city. What happens to the land?
A Khata essentially is an account number that is designated to a plot. E-Khata is something which allows and permits you to pay the taxes online. So your prerequisite to an e-Khata is a Khata number first. And essentially this is granted to an owner of the property. Now in the event as on today the property is under construction, then I doubt that you would be granted an e-Khata, and you have to wait till the construction is over and the property is transferred in your name, and then you can probably go and apply for a Khata number in respect of your property and then subsequently an e-Khata. As far as a change in number is concerned, I think so that will completely depend upon the dynamics as to how the transition happens. If the transition demands that there should be a change in numbers, and there would be, but ideally they tend to keep the same numbers. So that will depend on how and when it gets merged with the metropolitan region, and thereafter whether the number changes or not.
Right, last question on our show today. However, let me just quickly recap some key takeaways, some key learnings that we all got on the show today. Essentially, or as regards the occupancy certificate, now do remember that you are well within your rights. You can register a flat, the agreement for buying a flat without an OC, which is the occupancy certificate. However, taking possession of the flat is illegal without the OC. Not just taking, so the developer giving you possession is illegal, and your taking that possession is also illegal. However, in case the property has been delayed for a long time, you are being given OC, ensure that you seek legal consultation. Do go and take the advice of a lawyer and then choose to move into that property. That's all the time we have on today's episode of Property Hotline. Nirav Jani, thank you very much for coming in and answering all those questions. If you have any questions related to real estate, and that these need not be legal, it could be buying, selling, investing in property, it could be tax queries or even home finance queries, you can reach us, IDs flashing on your screens. We promise you we'll get the country's top experts to answer each and every one of your questions. Stay tuned to Magicbricks Now.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/Magicbricks Now. And don't forget to click the like button. You can also follow us on Twitter at Magicbricks Now. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/Magicbricks Now.